All right, good to be here. Hey, folks, I'm estate planning attorney Paul Rabelais. Jacob Duke is here. We were on a roll there and doing some live stream presentations about every other week, but as life and business gets in the way, it happened. And so me and Jacob had to reconnect and say, hey, there's some stuff going on here. We ought to, reconnect and put some content out there. So Jacob, welcome. How have you been?
Yeah, things have been great, really busy, but really good. Lots of interesting stuff to talk about here on some inherited IRA rules, which they never seem to finally get everything nailed down. It seems like maybe they do this time, but we wanted to kind of share what the latest is on that for everybody who's got inherited IRAs.
Yeah, we've got a bunch of new rules that have regulations that have been finalized, but let's maybe even back up for a second. I'm gonna put you on the spot, but how many of your clients, and I know you're getting clients from all over the country, but how many of your clients have maybe, let's call it an IRA, or maybe even more so, a better question would be a kind of significant IRA where kind of the bulk of their financial assets are in a retirement account? And I want to put this answer in context because these rules apply to everybody who has a retirement account.
Yeah, absolutely. I would say that 99% of my clients have an IRA or a Roth
That's a big
IRA.
number.
There's maybe 1% who don't. And even if they don't, I would say they have something open somewhere, 401ks may ultimately turn into an IRA one day as well. But I would say the majority of people's actual life savings is in a tax deferred or a tax-free account, such as a Roth IRA or Roth 401k. They're retirement accounts. And that's where most of people that I work with, that's where their wealth is held. Some have brokerage accounts, which are outside of that. But in general, these conversations, these rules, they apply to everyone that I work with.
Yeah, I do find, in estate planning, I'm handling the legal end, either during lifetime or when someone passes away. The number of accounts people have varies widely, but I just find generally that most people, have a traditional IRA, a Roth IRA, and then a brokerage account. I will say a lot of people mistakenly believe, and we'll get to this in a minute, that they'll tell me, yeah, I put beneficiaries on all my accounts, and there's different beneficiary rules for retirement accounts than there are kind of individual or joint brokerage accounts.
Yeah.
And then the married couples tend to have, each spouse often has their own traditional, their own Roth, and sometimes a joint brokerage account. So it's really common for married couples to have 5 or more accounts. And then it gets a little tricky to keep up with everything. So is that what you're saying?
Yes, it does get hard. Just in general, retirement accounts have so many different rules than a normal asset, like a brokerage account or a home or anything like that. They pass based on beneficiary designation. Wills and other things don't have any, say so on that. There's different distribution rules, which we're going to talk about today, after someone inherits those types of assets. So it gets really fuzzy really quickly on the retirement account side of things.
Yep. All right, so let's jump in. By the way, for those of you watching, I see we got a bunch of you on here, so feel free to use the chat. I see Susie. Great to have you back, Susie. And of course, I'll give you one guess who's showing up on my chat, Jacob.
Larry
from Bakersfield, California. Great to see you, and good to have you here. Saw you yesterday on one of my live streams, Larry. I was worried about you because I hadn't seen you on the last few, but some of my topics were kind of Louisiana based. So good to have you back. All right. Let's jump in. The timely aspect of this live stream is that just last month, and I think it was July 19th.
Of the last
2024,
three or 4 weeks. Yeah.
We've been waiting for a few years for these final regulations. What the IRS does is new law gets created by Congress. IRA issues these proposed regulations, and then they give the public and professionals time to comment on those regulations. And then they issue final regulations. So final regulations came out, and again, it's going to affect everybody. And there's various rules. I mean, they had to clean up a couple of little things that I'm not really going to get into. But to me, the major aspect of these Secure Act regulations has to do with what people typically call the 10-year rule. And I think the main rule that was clarified within the 10-year rule was if an IRA owner has, you could say, already or has not passed their what's called required beginning date, that date at which they must start taking these required minimum distributions. If an IRA owner passes away before their required beginning date, and they've left designated beneficiaries, that is a defined term as opposed to what's called eligible designated beneficiaries. If they left eligible designated beneficiaries, then those beneficiaries, there is no required minimum distribution for those designated beneficiaries. If the IRA owner died before their required beginning date, those beneficiaries can wait until year 10. We'll talk about some strategies here later on, but if they want to, their required minimum distribution, there's really just one. It's 10 years after the IRA owner who died before their required beginning date.
Which, Paul, the big thing there that changed in the 2022 or Secure Act 2.0 was the addition of that 10-year rule that we're talking about, right? So this was not the case before then. Everyone had the opportunity to do what's called a stretch IRA or use a stretch provision and distribute the RMDs, required minimum distributions, out of their account over their life expectancy. So if a parent passes away at 60 and the child is 25, that child has to take RMDs under the old rules, but they get to do it over their life expectancy, which means those RMDs would be fairly small, at least in the early stages of doing that. Now, that 10-year rule changed the game to where now everything has to be taken out of that inherited IRA by the end of that 10-year sequence. And like you were alluding to, whether or not you have to take money out each year, that depends on the type of beneficiary that you are. So I'll let you keep going as best you can on that.
Yeah, and on that note, I mean, my view, or at least my understanding, was the reason they changed the rule from allowing beneficiaries to take distributions over their life expectancy to the 10-year rule was to speed up when the IRS gets its money.
Yep.
However, if that 60-year-old, like you say, passes away, under the old rule, the IRS would start getting some money immediately in year one after the 60-year-old died. Take it, those distributions would not necessarily be large, but the IRS would be collecting revenue for the 9 years after the 60-year-old IRA owner died. Well, now under the new rule, the IRS oftentimes won't get any money until 10 years after the IRA owner died. So to me, it's kind of quirky. The reason for the rule was to speed up when the IRS gets its money, but in many cases, they slow down how quickly they get the money. So anyway, kind of odd there.
Yeah, I think it's safe to say that in general, these rules got more confusing over the last 3-4 years than they got clearer. One of the big points, again, but going back to that stretch provision, everyone had that opportunity pre these different legislations that came out. Now only specific types of beneficiaries, such as a spouse or a minor child or someone who's disabled or something along those lines, specifically the spouse, that's really the biggest one here. They still have that stretch provision opportunity. And that's who that applies to now, but everyone else does not get that rule. So it's it makes it more confusing in general.
Yeah. Yeah, that spouse now, it's the same rule for the spouse. The surviving spouse can treat that IRA as their own and wait until they're, well, is it 72 or 73 or 75? That age at which you must start taking distributions is evolving over the years. I think for a guy like me, who's approaching retirement and thinking about these things, I think the required beginning date for a guy like me, who's 59 years old, will be when I reach age 75. So we touched on the IRA owner who's 60, who passed away before their required beginning date. Distributions can wait until 10 years after they pass away. Different rule for an IRA owner who dies after their required beginning date. So if an 80-year-old passes away this year with an IRA and names, let's say, their children as their designated beneficiaries, then because the 80-year-old IRA owner died after his required beginning date, now those beneficiaries have to start taking required minimum distributions the year after dad died, based on the beneficiary's life expectancy. So it's like they can stretch it over their life expectancy, but they can only stretch it for 10 years. And then whatever's left 10 years after the 80-year-old IRA owner died, it all has to come out and taxes are paid on that. Is that kind of how you understand it, Jacob?
That's exactly right. Yep. So if the IRA owner passed away after their RMDs had started, in this case, anyone who had started their RMDs was either 70 and a half, they were 72, or they're 73. No one, I don't think at this point, has reached the 75 mark in terms of that's the required beginning date for anyone yet. We can talk more about that just to be clear in a second. But anyone who was taking their RMDs, if you inherit an IRA from that person, you will have RMDs starting the following year. And then you have to continue doing those for 10 years. And then by the end of that 10th year, all of the money has to be out of the account. So think about it this way, just an example, Paul. Let's say you receive a $100,000, IRA as an inherited IRA from someone. They were already taking their RMDs out of that account. Your RMD as, let's say, a 45-year-old would maybe be, $5,000, let's say year one, then maybe $6,000 the next year. So if you do that for 10 years, what's going to happen is the full account's not going to be distributed yet by following that schedule. Whenever you get to the end of the 10 years, whatever's left over still has to be taken out by the end of the 10 years. So a couple thoughts here and I were talking about briefly was, should we follow the normal lower amounts that we have to take out, just the minimum distribution amounts we must take? Should we do that and then take out a big chunk at the end to meet the 10-year rule? Or should we break those out into larger payments over this 10-year period, take more than we have to, so we don't create a big tax bill in one particular year? So there's some strategy that kind of goes into some of these different things too.
Right. I think the age of the beneficiary, the employment or retired status of the beneficiary may play a big role in that strategy on when to take those distributions and how large of a distribution people should take over that 10-year period.
For sure.
So in fact, I'm bursting at the seams because I'm so excited. Before we got started, Jacob showed me a resource that he had. And so I'm going to get you, Jacob, throw that sucker up on the screen. And Larry, we're going to see if you can follow this thing along. But I think, I don't want to speak for Jacob, but I think he wants to make it a resource available, which I want to get it. To me, it would be a great cheat sheet. And maybe Jacob, you can talk about that and
it's a quick little,
and how people can get that if they want it.
For sure. Yeah, it's a quick little flow chart. Because again, all this stuff is very confusing. And so hopefully it's a helpful tool for you to kind of walk through, you'd start here and kind of flow through this and just go like we talked about. Did you inherit this from a spouse? Yes or no? Did the spouse pass away after a certain date? What do I do next? And are you a eligible designated beneficiary or a non-eligible designated beneficiary? As we mentioned, did the owner pass away before or after their required beginning date, as you already have been talking about? So you kind of flow through this and see, hey, what are my rules because of who the person was and when they passed away? And then that will dictate what my obligations are as someone who's inherited it. So if you're watching this and you want this resource, I'll happily send it to you for free. Just shoot me an email and it'll be down in the description of the YouTube video, or shoot Paul an email and we'll get the resource over to you so you can use that to your advantage.
And I see, I don't know if you can make it any bigger, but I see on the very bottom, it was updated on August 15th, which is today.
Yeah. Okay. Yeah, I just got a new one today.
All right. Susie is asking, will you cover TSP? Any remarks you want to make about that, Jacob?
I mean, technically, let's see. Paul, do the rules apply the same for TSPs as they do IRAs?
You know what? I don't know.
I think it's safe to say we don't know at this point. I mean, I'm not going to try to act like I do.
Yeah.
I would say that no matter what, you're going to have RMDs of some sort, right?
Yeah.
In theory, though, what would happen there is what would happen is the TSP would be paid to you. I mean, you would have to do something with that money. You cannot have that money there still. So you're going to open an inherited IRA. So it will become an IRA. Yeah. I'm fairly certain. So you would essentially follow these same rules.
Yeah. Congratulations, Susie. I rarely get stumped, but you did it. So congratulations. All right, but I'm sure next time I read through the regulations, I'm going to be looking out for that, Susie. So stay with us here. Okay, so yeah, there's all the rules, there's all the regulations, there's final regulations, and we touched on the fact that there's these defined terms of designated beneficiaries, which are the typical beneficiaries. It's children, but there is this class of eligible designated beneficiaries.
Yeah.
Those are beneficiaries who get kind of preferred payout treatment. They typically can prolong.
They can use that stretch provision.
Yeah. So spouse. If you leave things to a spouse, that what most spouses do is they just treat it as their own. I know if there's some big age gaps, it can be different. But on the minor child rule as an eligible designated beneficiary, a couple of areas where people get tripped up. One is they think any minor beneficiary qualifies under this minor child as an eligible designated beneficiary, but it truly is just the children of the IRA account owner. A grandchild who's 12. Yeah, no, not a grandchild, not a niece, nephew. It has to be a child of the IRA owner. And what they'll get to do is they'll get to wait until they're 21, take those, and then they'll take final distributions at 31. But so that's one. Chronically ill or disabled, we don't see a whole lot of that, but it does happen. They get the longer payout, and then also beneficiaries who are not more than 10 years younger than the IRA account owner,
which is an interesting one, right?
Yeah,
that's an interesting one because let's say Paul gets hit by a bus. His sister is 5 years younger than him. He's got hers, the beneficiary on that. She technically can use that stretch provision to her advantage, and she is now an eligible designated beneficiary because of that age gap difference. So a little bit.
You're talking about my sister?
Yeah.
That's funny. Yeah, no. Well, she'd have to first fight my 5 kids for it, or fight my spouse for it, and then she'd have to fight with 2 other sisters that I have. But really, that is the case.
Paul, a question for you I had real quick on the minor child thing, and it's maybe an estate planning question for you. Always a hard one with minor children involved in terms of who gets what, and do we name them as beneficiaries or not? Let's say we did on an IRA. They do not have to start their distributions until they reach that age majority, or 21 is what the legislation defined it as. So they have to start taking it at 21, or can start taking 21 at the end of, by they reach age 31, it has to be out of the account. But is there a way from a estate planning standpoint? Obviously some parents don't want their kids to get all that money or access all that money at 21. What can be done to help with that, but also maybe not increase the taxability of that money?
Well, that's the way you phrase that question is funny, because since you phrased it that way, I'm going to say the answer is nothing. So yeah, let's say you have a child and child's 19 and you're saying, geez, if I pass away, I don't want that child getting a penny based on their present behaviors and their immaturity or whatever reason. I don't even want them getting these required minimum distributions. Sometimes we have IRA owners designate trusts for those young children as beneficiaries. But here's the deal. When there is a required distribution that must take place, and let's say that the child is 22 and there's a required distribution, it can either go into a trust and then paid out to the 22-year-old. And of course, 22-year-old gets their hand on the money and they pay income tax on it at whatever income tax bracket they're in. Mm-hmm. Or that required distribution can be paid to and accumulated in a trust. You have to make the distribution because now the child's 22, but it can be distributed to a trust and just let it sit in the trust. But now the trust has to pay the income tax at higher trust income tax rates. So most people say, I prefer the method that results in the least amount of tax being due. And with that, they're saying, okay, well, I don't know that my child in their 20s could handle money, but if a required distribution is required, let's let them have it because They pay little or no income tax, and I want the least amount of tax to be paid. But other people will say, I don't care if extra tax has to be paid on that distribution when it's accumulated in a trust.
Right.
That distribution would do more harm than good for my 22-year-old. I'm okay with letting that distribution go into a trust, having it accumulated, have the trust pay income tax at higher trust income tax rates. And then let's provide a mechanism for our child to get those funds kind of way down the road.
Yeah.
So yeah, it's a balancing between, do you want them to get their hands on it and pay income tax at the child's lower rate, or do you want that distribution to accumulate in trust, yet have a trust pay the income tax at higher trust income tax rates? There's no right or wrong there. It's the key is to just allow those parents to make informed decisions.
Yeah. There's no perfect way around that, as basically what I heard. What about Roth IRAs? What about those? Those are a little bit different than traditional IRAs.
Larry, in the research is
right, but what's the kind of new rules on that?
What I think I went out for a minute. What was the question there, Jacob?
It was Roth IRAs. So obviously those don't have RMDs for anyone while they're alive. How does this apply to these different rules here that we've got today for inherited Roth
I'm pretty
IRAs?
sure the case is, there's all the money's got to come out, by that 10th year under the 10-year rule. So that's the strategy. That's the kind of common sense strategy for most, unless some crazy circumstances apply. If you're a beneficiary of a Roth IRA and you're a designated beneficiary, don't take any distributions until you have to. Take it all out at the end of the 10-year period. You're allowing those investments to continue to appreciate, and there will never be income tax paid on any of that appreciation. So let it continue to grow for the 10-year period. Take out the big chunk 10 years later, and then get Jacob to invest it for you.
Yeah. So one of the big thoughts there is obviously, number one, like you just said, leave the money in that inherited Roth IRA as long as possible so it keeps growing tax-free. Whenever you take that money out by the end of the 10th year, it's not taxable, which goes into one of the overall strategies of retirement or financial planning in general, which is, use your Roth IRA as you can in retirement. But a good thought is, if you are going to leave money to someone, a child, a spouse, somebody in the future, and they're going to have to distribute this money out, do it. But leave the Roth IRA rather than a traditional IRA because of the tax consequences potentially of that. So there is some strategy, again, into which money you live on in retirement and where you pay taxes and when you pay taxes. Because if someone receives a large traditional IRA in the future and they have to do this 10-year rule, they could be in a bind if they're a high income earner or something like that.
Yeah. And then one other thing, I feel like I'd be remiss if I didn't even mention it before we got off the live stream here. And it isn't really related to the new Secure Act rules, but it's just a big mistake that people have made for decades with their IRAs. The issue rears its ugly head even more so when you have what I call blended families. When you have a husband and wife or a married couple who may get married later in life because perhaps their first spouse, they were either divorced or the first spouse passed away. So you have a situation where two people marry, they each have their own children. And this is the problem. Just because it happens this way and just kind of by default, and there's just not a lot of thought put into it. When let's say that husband, when he opens up his IRA account, he's just thinking, I want to take care of my wife and my kids. So let me name my wife as my primary beneficiary and then name my kids as my contingent beneficiaries. And he's thinking, okay, after me and my wife pass away, then my kids will get all my IRA money. That's exactly what I want.
Yep. The
problem there is when the husband dies, since his wife was the primary beneficiary, and under the rules, she can treat that IRA as her own. All of his IRA goes into an IRA in her name, and she can designate whoever she wants to as the beneficiaries. And of course, as the old story goes, she designates her children as her beneficiaries. And so that husband arranged things so that he really disinherited his children. So even though it's kind of common sense, naming your spouse as your primary beneficiary and your children contingent beneficiaries doesn't guarantee that your children will ever get any of that IRA. The only guarantee is if your spouse predeceases you and then you die, and then it goes to
Right.
the children as contingent beneficiaries. So, especially in the blended families, what we see a lot of parents thinking is a pretty good idea is instead of just naming the spouse as the 100% primary beneficiary, and I'm making up numbers here, but let's say husband has a $2 million IRA. He wants to provide for his spouse, but he also wants to protect his children. Maybe instead of just naming, wife as primary beneficiary, kids as contingent beneficiaries, maybe he'll say, well, I'll leave 40% of my IRA to my spouse, and that will be hers to do what she wants to with. I have $2 million. That would be $800,000. The value will change, of course. And then I have 2 children, and I'll name my children, each of them 30% beneficiaries. That way they'll get some things when I pass away. My spouse can't kind of disinherit them by leaving it all to my spouse's children. Right. And also provides that the children of the husband don't have to wait until the surviving wife dies to receive an inheritance from the husband. So just be aware if you're married, and it's not just a blended family situation. We've seen a lot of circumstances where just in the traditional one marriage, children of the one marriage, I often say the husband dies first because most husbands think they're going to die first, but I know that's not always the case. I'll give you wives some credit. You die first sometimes too. But even the traditional family, you see sometimes the husband, naming his spouse or his wife as his 100% primary beneficiary. That's what most people do. And then circumstances change after the husband dies and the wife remarries. The wife may get influenced by one and may end up disinheriting the children. So married couples, there's just make an informed decision. And sometimes it's appropriate to name children as primary beneficiaries along with your spouse. Just know that you have that option.
Yeah.
I'll leave it.
There's a lot there. And so it's typically more than meets the eye in terms of naming beneficiaries, at least correctly, and that actually happening, what you want to happen, which is the importance of an estate plan, in my opinion. And to that point, even as, combining your financial plan in general with your estate plan so that they actually work together. Because like we've talked about before, if you open a trust specifically for these different blended families, let's say in the, situation you just mentioned, and we don't name the trust as the beneficiary on the IRA, the trust does not matter, right? So we have to combine both of these things and make sure they're working together correctly.
Yep. Rob's asking, do you have to pay federal income tax on inheritance every year until it's gone? So, sometimes I read these questions and I'd love to be able to ask more questions to clarify the question, but I did a live stream recently, just in the last couple of days. It's, what are the taxes when you inherit? So you may want to check out that live stream, but I'll give you the 15-second answer. Generally, an inheritance is income tax free. So if you inherit a bank account, or if you inherit a brokerage account, or if you inherit a car or even a home, you don't pay income tax on the value of that inheritance. It just so happens that the main topic of this entire live stream has been inheriting an IRA, where there are significant income tax consequences. So to inheriting an IRA, or at least a traditional IRA, someone's going to pay tax on that traditional IRA, whether it's the original IRA owner or their spouse or other beneficiaries. So there's no getting around that. But yeah, generally speaking, Rob, an inheritance is free of income tax. Now, I will say, if Rob, and I'll throw some numbers out there, you inherit $1 million, that $1 million that you inherit, again, as long as it's not a traditional IRA, you don't pay income tax. However, as that $1 million of assets starts to produce income, whether that income is interest or dividends, of course, you'll pay income tax on that income that's produced from the principle of your inheritance. So Rob, keep listening. We got a lot more where that came from. Thanks for the question.
Yeah. In the context of today's conversation around the traditional inherited IRAs, the answer is yes. Like you just said, you will pay income taxes at the federal and state level. If you have a state that has income tax, you're going to pay income taxes on the distributions in which you take, which goes back to the strategies that we were talking about. Number one, do you have to take an annual amount from the account? That's the first question. Flow chart, I can help you with that and send that over to you. The second question is should I take out the minimum amount every year if I'm forced to take something? Or should I take out more than the minimum so that I don't want to create a large tax bill in one particular year? Because remember, by the end of that 10-year sequence, you have to have all of the money out of the account. So if you got $1 million inherited IRA and you're required to take $40,000 out, let's say for 10 years, well, that's only $400,000. Now you get $600,000 to take out in the final year on top of your $40,000, all in the same tax year, could push you into really high tax brackets. So the strategy around when to take your distributions is going to be very important.
Yeah. Super. All right. I think we're about ready to wrap it up here. I do want to encourage people to check out, and I'm going to do it as well. I want to take a good hard look at Jacob's little chart there, and so he's offering that as a free resource. So feel free to take advantage of that. So looking forward. Kind of Jacob and I have a tentative plan. Maybe once a month you'll see us on the live stream. So look forward to continuing to educate and share information with Jacob. By the way, let me see. We got LV who's saying, hi, Paul, if an estate exceeds 13.6 federal exemption and the estate includes a sizable tax deferred 401k with the money in the tax twice. So sort of. So yeah, let's say a person dies and their only asset is a $20 million IRA. And I know it's crazy. That never happens that way. So the first thing that happens is, there's a big chunk of estate tax paid within 9 months of the IRA owner's death because their estate, and which includes their IRA, exceeded the $13.6 million exemption, as you pointed out, LV. So yes, the estate tax is paid first. And then there's a calculation made as the beneficiaries are receiving their distributions. They get a credit on their income tax for the estate tax that was attributed to that distribution. So it's a complicated formula. I don't see it much, but somewhat of a not fully taxed twice as you might think, being full estate tax and then full income tax. You got a 40% tax and a state tax, and then another 40% income tax. There's going to be nothing left. So they do give beneficiaries the opportunity to have a credit on their income tax for the estate tax that was attributed to that district.
Paul, did we lose you?
Yeah, I think you did. So I think it's my internet connection. Can you hear me?
Yep, I got you now.
Yeah. Okay. So anyway, just wanted to see if you wanted to add anything, Jacob, and you can sign us out since my internet connection is bad.
Yeah, I don't think there's much to add other than this. If you are not taking your RMDs, let's say you're 72 or 70, and you're not taking your RMDs yet, you're someone who's not, your RMD age, your required beginning date is going to be either 73 or 75. If you were born from 1951 through the end of 1959, it is going to be 73. If you were born 1960 or later, your RMD age, your required beginning date, is going to be 75. So that's hopefully a helpful little tidbit there for you to know when your RMDs will start under the new Secure Act rules. So other than that, Paul, this was fun. I'm sure we'll get some questions. If you do have questions, shoot us an email. I've got this resource for you. Shoot either Paul or myself an email. We'll send it over to you, and hopefully it's helpful.
All right, guys, we'll see y'all next time. Looking forward to it. Thanks, Jacob.
All right. Thanks, Paul. Bye.